Welcome everyone. Thank you for joining us this afternoon for the Garden Court webinar. You've all been placed on mute, I'm afraid. Sorry, we can't hear your friendly voices. Please put your questions in the Q&A function that you'll see on your toolbar. The chat function is available if you want to put in any queries or comments or feedback, but please don't put questions there because we may miss them. So please put the questions in the Q&A. The resources are going to be circulated after the webinar to all those who have registered as delegates. And that's my opportunity to say if anybody feels a bit zoomed out and sneaks off early, we won't know, and you'll still get access to the webinar afterwards. The webinar is being recorded. You will have clicked OK, I think, to have joined and given your consent by that. And what that means is the audio and video of the panelists and anyone who speaks, if they're unmuted, will be recorded. The webinar may be shared on marketing channels, including website and social media. So that's the housekeeping over. Save to say on the technical front, I'm afraid I'm not the person to ask. And so the instructions are in the chat window if anybody has any difficulties with the technology. So thank you again for joining us. Our panel this afternoon, in order of speaking, will be Bethan Harris first of all, convener of the Court of Protection team here at Garden Court and an established community care and housing practitioner. And she'll be talking about when should a fact-finding take place, what are the advantages and disadvantages of it, and the relationship between the fact-finding and the safeguarding procedure. Then it'll be me, member of the COP team here and mental health practitioner, and also a mediator on the Court of Protection mediation pilot scheme. And I'll be dealing with evidence and disclosure. And then Mai-Ling Savage, also established member of the COP team and a family practitioner, will be dealing with vulnerable witnesses and the participation of those vulnerable witnesses in fact-finding hearings. And then finally, last but not least, Rachel Sean, who is a relatively new addition to the COP team and a family practitioner, and she'll be dealing with what we're all coming to live with, which is remote hearings and dealing with those during this pandemic. So without further ado, I'm going to, if I may, put myself on mute and hand over to you, Bethan. Thank you.
Thank you. So I hope you can hear me and that you can see the slides. Thank you. Well, I'm going to speak about the two topics that Helen has mentioned. And first of all, I'm going to give a short introduction to our topic this evening. The first few bullet points by way of introduction. What is fact-finding in the Court of Protection? Well, it's the process that we need in order to decide on the factual foundation for the decision that is ultimately going to be made on best interests in the case. So if the material facts to that best interests assessment are not agreed, then a fact-finding process may well be necessary. The facts in issue, as we know in fact-finding hearings in the Court of Protection, can have serious implications for P, the person who lacks mental capacity, for their safety and welfare, and also for the persons against whom they're sought in terms of the future for family relations and reputational damage. So they can be very serious allegations, indeed serious consequences. And typically findings are sought by a public body in relation to an individual connected to P, or they're being sought in a case involving allegations being made by one family member against another, typically in a dispute about who should care for P. Examples from the case law that is referred to in the course of these slides of the kinds of allegations that are made are allegations of assault inflicted on P, that there have been plans by parents to marry P off to a person abroad, allegations against family members of speaking to P in a critical and derogatory way, and a whole variety of allegations against family members stating that P suffers from conditions when that's not the case, being unable to work with professionals, keeping P away from other family members in order to get their hands on P's benefits. These are just examples of the types of allegations that have come up in the case law. And they may be multiple, and the hearing may be very long. The hearing in A local authority against M, for example, lasted 20 days, 32 witnesses, no doubt elongated because there were litigants in person involved in that case. And the AB case and Hammersmith and Fulham, cross allegations and cross allegations, Scott schedules running to over 100 pages. So sometimes very lengthy hearings can't be avoided in order for these quite complex factual matters to be properly decided. The decision as to whether there should be a fact-finding hearing will be taken early on in the course of the proceedings at a case management stage. So obviously that means that as legal representatives, we need to be on top of the case early on in order to identify whether fact-finding is going to be the way to go or not. And the court will determine not only whether there should be a fact-finding inquiry, but also what the scope of that inquiry will be. For example, in the LBX against TT case, there were allegations of sexual abuse against a family member, the partner of P's mother. And it was decided that it wasn't actually necessary that the fact finding should make findings on whether those allegations were true, because that individual was not going to have any more contact with P, and was that matter was simply going to take its course in the criminal courts. So it's a matter of whether to have it and what its scope is going to be. And when the findings of fact have been made, then, to make an obvious point, but obviously an absolutely vitally important one, those facts that are found will be treated thereafter in the proceedings as the basis upon which all further decisions and assessments will be made. So that means all expert assessments that then ensue must proceed on the basis of those facts. It also means that it's very important that the judgment itself is expressed in clear terms as to which facts have been found to the required standard of proof, and that there's no muddle about that. And judges will be alert to that, but it's also a reason why it's always wise to address the judge on the burden of proof and the relevant standard of proof, which are matters that Helen is going to deal with in her talk. And another point of principle, it's wrong for a judge to go beyond what is being asserted in the findings that are set out as the findings that are going to be sought in the fact-finding process. And that's for obvious reasons. Of course, the evidence will be gathered on the basis of what are the stated facts at the outset that are being advanced. And also cross-examination will have proceeded on that footing. That error was made in the family case that I've cited there, which is actually a case which I think Mai-Ling was in which the judge went beyond what was being asserted in attributing the fact that a child self-harmed to the conduct of the parents, which wasn't actually what the local authority was suggesting in its asserted facts. And then a final introductory point, a hearing on best interests combined, or a split hearing, or indeed it could be a combination of a hearing on capacity and a fact-finding hearing. Most often in my experience, the fact-finding hearing has been a discrete hearing and not combined with best interests, but it could be. If the hearing is split, then the proceedings are part heard after the fact-finding process has taken place, which means that the same judge needs to hear the next stage of the proceedings when the best interest issues are determined in light of the findings of fact in the fact-finding process. So now I'm going to move on from those introductory points to talk about when should there be a fact-finding hearing, and what are the principles and what are the kind of things that we take into account when we're advising our clients on this issue at the case management stage. Well, the first point I'd like to make is that when we do give that advice, we adopt generally quite a pragmatic approach. Obviously, we need to have reference to the principles, but what we're likely to be doing is looking at what are the possible realistic outcomes and what's going to get our client to what our client wants to get to. So it does take pragmatism as well as principle. And within that process of consideration, there is quite often a strong strand of wanting to be able to reach an agreed solution. And Mr. Justice Charles highlighted how a fact-finding hearing can help or not help in the endeavour of preserving relations for the future. And these are his very wise words. In this type of litigation, which is concerned with human relationships, an agreed solution is likely to be beneficial in the short, medium and long term. And in some cases, it may be easier to reach agreement if the disputes of fact have not been defined and the battle lines of litigation thereby set. And I'm sure when you hear that phrase, as I do, you can just imagine the sort of situation we're talking about where battle lines become set in the process of litigation. Because obviously that's likely to increase confrontation and harm future relationships. But then he refers to how there are situations where it can be of assistance in reaching a negotiated solution for there to be a process of fact-finding. And that, of course, is a situation one has to recognise where the facts of the past are just not going to go away, or indeed of the present. It's going to lurk, or it's going to be central and determinative of how things need to be arranged ongoing. So these are the judgments that we have to make. So looking at what we get from the case law in terms of the principled approach to this decision, the key statement of the principles comes from a case before the Mental Capacity Act, the case of the decision of Mr. Justice Wall, which is cited in what is the main authority, which is a decision in the COP re AG. So the judgment of Mr. Justice Wall states the following principles. If there are disputed issues of fact relevant to the evaluation of the options for P, the court may need to resolve them if their resolution is necessary to the decision as to what is in P's best interests. So that really is the core point. And if you go to the final bullet point there, you'll see that that's really stated again very clearly, that there's no rule beyond the principle that the approach to best interest must be evidence-based. The irrelevant must be excluded, but all relevant material taken into account. So we need to know what are the facts that underlie the decision-making as to the best interests of P, and if they're in dispute, they may well need to be resolved. And on the one hand, looking at bullet point 2, you'll have some cases that are very fact-specific, where it's completely clear that the facts need to be decided, and you'll have other cases where, and this is many cases in the Court of Protection, in which the principal concern is the future and the relative suitability of the plans each party puts forward for the care of P. And then we have a word of warning there about the dangers of a too lax approach to historical issues. If those historical issues are just going to lurk and make it difficult to make decisions, then they're going to have to be decided. So looking a bit further at re AG, and this may be a case which is familiar to many people here this evening. I'm going to take you through it in a little bit of detail because it is very useful to have the principles really at the forefront of your mind when you have to advise a client on whether you're going to argue in favour of fact-finding hearing or against having a fact-finding hearing. And of course, that decision is quite a big one, quite a big emotional investment in that process. Obviously, it's going to make the whole proceedings much longer. So it needs careful thought. In this case, the facts were very briefly, And they are in many ways typical of where this situation arises, where the decision about fact-finding or no fact-finding arises, where we have an adult who has a learning disability and ASD in this case, living at home with mother and then moving to live semi-independently with a care package, an allegation that mother hit her, mother alleged that AG attacked her, mother was saying it was difficult to look after AG, there were tensions, safeguarding inconclusive, AG continued to live in her own flat, further allegations made that mother was abusive, AG was also said to have assaulted a care worker, then AG decided she didn't want to visit her mother, care providers terminated the contract, and then the local authority removed AG to a new placement without seeking a court order, which of course it should have done. So that's another point in this case. Obviously, where a person who lacks mental capacity is being removed from their own home in a situation where that's contentious, which it plainly was here, then that should only be done once a court order has been sought. But it was after that they had removed AG that the local authority in this case applied to the COP. And the judge at first instance made the decision as to whether there would be a fact-finding hearing, and the local authority did not want to have a fact-finding hearing, whereas the mother wanted to have a fact-finding hearing because she wanted to clear her name of the allegations that had been made against her, which had caused the removal of her daughter. And the first instance judge held that the court wasn't going to devote what it considered to be disproportionate amount of time and resources to that investigation, and that we must start from where we are now and look to the future, which sounds quite straightforward, although it's not so clear-cut as perhaps is indicated by the point above it. Although the past would feature to some extent in the background, even if some additional factual clarity would have emerged, it would not materially have affected his overall approach to the case. So you can see that there's a judgment to be made there. And if I could just go to that very last point, sorry, if I just go back. The allegations were strongly denied by the mother, but he held, and this is obviously an important point, that they weren't going to be held against him as some sort of suspicion lurking over the mother in the background. Obviously, that's a very important point for a family member. And the incorporation of essentially that point in a preamble, as indicated as was done in this particular case, is very useful mechanism for clarity and reassurance. And you'll see that preamble there, which states the position, no fact-finding hearing, and what that meant, that the facts that were in contention were not proven. So that's a useful practice to adopt. And then what happened in the case was an outcome which the mother was not wholly happy with, in that her contact was according to a structure of supervision which was imposed by the local authority. So she appealed on grounds which included that there had been a failure to make findings of fact in relation to the events that had triggered the proceedings. The allegations were serious, and she should have had an opportunity to have been heard and to defend herself. And one can understand that a person would feel aggrieved in that sort of situation. And the decision on the appeal by Sir James Mumby, who was president of the Court of Protection at the time, in 6 points was, first of all, the judge was right to have followed the principles of Mr. Justice Wall. The judge had correctly spelt out the legal consequences of there not being a fact-finding hearing. There was nothing in his judgment which suggested that he'd then gone and done anything differently. And the decision not to have a fact-finding hearing has to be looked at in its context. This was one of those cases where you were looking to the future. Things had moved on, and it was all about what was going to come next. The level of inquiry undertaken was sufficient to inform the decision as to the future planning, which is the key point. That's the analytically what we have to look at. And then finally, there was nothing to suggest that the independent social workers' analysis and recommendations were adversely influenced by the allegations. And that's a very important point. Obviously, the further instruction of an independent social worker or any expert has to be very clear that it's the recommendations of the opinion is being sought on the basis of the facts found, and that report, when it comes in, needs to be checked that it's clear that that is indeed the basis upon which the opinion has been given. And then a very human and important point made by Sir James Munby at the end of the judgment, that local authorities need to appreciate and take appropriate steps to minimise the understandable distress and anger caused by someone in the mother's position when allegations are made and they're not pursued. And that is something that we encounter very much in advocacy in the Court of Protection, where allegations are made, and they may have been made in quite appropriately, but ultimately also quite appropriately not pursued, because it turned out that the evidence, different light was cast on the evidence, or it just wasn't necessary. And if they are then not proven, they haven't been established, and matters need to proceed on that footing. And it's important, of course, for future relations that it's very clear that that is understood on both sides. It can be, of course, very distressing for individuals to have allegations made against them which are not true. Now, a few words about local authority safeguarding duties and fact-finding in the Court of Protection, and I'll be very brief with this. What we're looking at here is where the local authority is bringing the case to the Court of Protection as part of the discharge of its safeguarding duties to vulnerable adults. And obviously a lot of cases in the Court of Protection are brought on that footing. And essentially there's one theme really in this part of the talk, which is how important it is that the investigation, which comes under the umbrella of the local authority's safeguarding functions, is done in a sufficient way so as to provide a proper foundation for bringing the proceedings. And also, if proceedings have to be brought urgently and the investigation cannot have been carried out in advance in the fullest sense for reasons of necessity, that there is very quick taking of stock and of further steps in the investigation that can be taken after the proceedings have commenced. And those really are the two main points. So just very quickly to take you through the remaining slides. First of all, the safeguarding duties, section 42 of the Care Act, underlying duties under the Convention of Human Rights as to why local authorities have to get involved in this area. And then the very important principle that if there is to be an intervention in relation to a person lacking mental capacity, which interferes with their Article 8 rights, then that does require an order from the court. Obviously, they can't consent to that step. It has to be authorised, and it would be a breach of their human rights if it isn't properly on a proper footing. And that then principle extends to the factual basis for underpinning that intervention, which is why there may need to be a fact-finding process. And I'll just move to my next slide. Yes, and just to make an obvious point, of course, there's no threshold criteria as there is in relation to public or family proceedings. It's just a question of best interests, and it may be an urgent intervention that's required, as I mentioned, before the full safeguarding process of inquiry, of investigation has been carried out, because it's not possible to do that because people might be alerted, that might put P at risk, or because there's just simply urgency to protect P from what is perceived at that time on a reasonable footing to be the risk. Obviously, care has to be taken in making these applications. And after taking that immediate step, it's very important that the local authority should then continue with what appropriate investigations it can and take stock expeditiously of the evidence. And I will finish with a brief mention of two cases. One of them is the case of HS, heard by District Judge Eldergill. An allegation, very serious allegation, was made of sexual abuse against a brother of a young woman who had Down syndrome. And the court identified a series of serious flaws in the investigation prior to the commencement of the process. And the court found that the local authority is expected to investigate and analyse the evidence before it starts the process, not to the standard that its barrister had done by the time the case had got to the point that the case was being decided on the question of whether the local authority should pay the costs of the proceedings. But it should have done a very much better job than it had. And had it done that, it would have rejected those abuse allegations and would not have issued proceedings. And that was the finding that the court was made. There was a prolonged failure to investigate and to apply any proper critical analysis. I think those perhaps are the key words to the evidence. You have to do the hard work in looking at the evidence critically and analysing it at an early stage. And the judgment is a very good reminder of all the things that can go wrong in a safeguarding investigation. And finally, a case where there was a removal of P in an urgent situation, wrongly without applying to the court. And subsequent to that, the criticism was made of the local authority that having taken that urgent action, it could have concluded very quickly that, in fact, the allegations, i.e. of assault by bruising against a family member, it could have concluded on its further investigation that they weren't going to go anywhere, and it shouldn't have prolonged the process, which it did prolong, and ultimately had to withdraw the allegations sometime later. In that case, the local authority was liable in damages under Article 8. So that's everything for me. Thank you very much. I'm going to stop sharing. Yeah.
Thank you very much, Bethan, for that. I'm going to now pick up where you left off, and bear with me just a moment. Hopefully I can make this work. Are those slides visible? If one of the panelists can say yes, I've got a thumbs up. Thank you very much. Good. So I'm going to touch on three topics: preparation, and then evidence and disclosure. And to start with, really picking up on that last case that Bethan mentioned, where things went very badly wrong, setting a bit of a context, really. Two quick quotes. Making findings of fact is a complex process which depends upon the judge's evaluation of the whole of the evidence presented and of the witnesses who appear before him or her. It's only when the whole jigsaw is assembled that the weight of an individual piece of evidence can reliably be determined. And that was Lady Justice Black, as she was in 2013. And then this faulty recollection or confusion at times of stress, or when the importance and accuracy are not fully appreciated, or there may be inaccuracy or mistake in record keeping or recollection. As memory fades, a desire to iron out wrinkles may not be unnatural. A process that might inelegantly be described as story creep may occur without any necessary inference of bad faith. And that was Mr. Justice Jackson, as he was then in 2014. And I just include those to give us the context of what we have to do to untangle this fact management exercise right at the outset. So we have to scope out, what are we looking at? Where will the evidence come from? Will it be admissible? If it is, what weight will be attached to it? How persuasive is it? How cogent is it? Is the witness a professional or lay witness? What's the source of their material? What will they be looking at? Will they have documents or logs or incident notes? Are there interviews with other people? What has P said about any of this? Will any information be forthcoming from P? May P even be attending at court, not, of course, being subject to cross-examination? So that's really about starting from the outset with a forensic approach to looking at what the evidence really amounts to, looking for corroboration from witnesses who can speak to events that have been communicated by P, and checking what those documents reveal. So the preparation, everybody understands what a Scott schedule is, and it's set out here, just a brief description. It's effectively a table, but it's like a pleading, if you like, in a civil case, or an indictment in a criminal case. And what it contains and must contain is fully particularized details of what it is, what the case is that the person who's facing the allegation or allegations has to meet. So it identifies when and what happened. So it can't just say X failed to provide care to P. It's got to be sufficiently particular so that X knows what they are effectively having to explain and potentially admit in part if something went wrong, or deny completely. And then there's the opportunity for a reply to that response. Very often the court can look at a Scotch schedule and encourage people, parties, consistent with their duty under the overriding objective, to get proportionate, to get focused, and to really shake it out, to use a colloquialism, and work out what is the extent of the factual dispute. What's a witness template going to look like with timings? Do you need interpreters? What's going to affect the hearing length? And then identify what are the conclusions that each party is going to invite the court to draw. How many allegations need to be proved? If they are proved, what are the consequences of the facts that are found, and what will you be asking the court to do as a result of that? So the burden and standard of proof, I agree with Bethan, it is important to set this out because I'll explain in a moment, but the burden is of course on the party bringing the allegation, who must prove the facts which underpin it. And this is not the same as the balancing exercise which the court undertakes when it determines P's best interests. It's not a question of preferring one or another in alignment with the Section 4 checklist of what is in P's best interests. It's a legal burden of proof. And I don't mean to be overly light-hearted, although I'm always looking for glimmers of light-heartedness in these challenging times. But a shipping case was not what I expected to include when I thought I'd do the slides for this webinar. But Lord Brandon did say in this shipping case, and it was because the court below, in fact, Mr. Justice Bingham, as he was in 1985, had effectively felt compelled to choose between two theories of why this ship sank. One was, on any view, extremely improbable, and the other one was impossible. But he felt compelled to choose between one of them. And the House of Lords said, really, you don't have to do that. You have to look at the burden, and has the burden been discharged? Do not feel driven to find something as proven if the burden isn't satisfied. And I've just included this for a bit of light-heartedness because Lord Brandon quoted from Arthur Conan Doyle, Sherlock Holmes and Watson. It's not the approach for fact-finding, obviously, that if you eliminate the impossible, whatever remains, however improbable, must be the truth. That's not the approach, but it was included in that judgment. So there's the burden. It's a heavy burden. It has to be discharged. And if it's not done so, then that didn't happen. The finding can't be made. So the standard of proof is just that. It's on the balance of probabilities, no more, no less. Either the fact can be found because it's established, or it cannot be found. There's no obligation on the respondents to provide an alternative explanation. For example, where there's an alleged injury and there's no need for the person who's alleged to have caused the injury to come up with a theory as to why that injury was sustained. Bethan's already mentioned Mr. Justice Baker's case of a local authority against M, and in that the standard of proof was reiterated. It's not the seriousness of the allegation or the seriousness of the consequences that have an impact on the standard of proof. The standard of proof remains the same. It's the balance of probabilities. So going to a couple of cases, this was in my view, quite a significant case, even though it's now old and there's new court protection rules and things like that, because it was the first time that some of these issues had been discovered in the end, had to be considered, sorry, in the Enfield case. It involved P, who was SA, who was denying that she had been abused and repeatedly asking to go home. Proceedings had been begun because during a consultation with the GP, it had come out in conversation that she was to be married and there was a concern raised. But in any event, the proceedings which dealt with all manner of things, one of which was, well, is hearsay evidence admissible in the Court of Protection? The answer is yes. These are civil proceedings within the Civil Evidence Act. Other specific issues were in relation to the hearsay evidence of what SA had said in terms of disclosures to her drama therapist. In that case, the judge took account of the fact that whilst impressed by the drama therapist in evidence, had to take note of the fact that out of the 120 sessions, there were only extracts from 9 which formed the witness statement. The local authority was in possession of the notes of the therapist, but the drama therapist objected to their disclosure. So the judge was left with not very much. He felt, saying this, whilst in no manner doubting the accuracy of the information that's been reported by the drama therapist, the court must be careful in the evaluation of this material in the absence of the ability to see it in the context of SA's presentation in the course of these sessions as a whole, or even the particular sessions upon which reliance is now placed. And there's obviously a risk there for there to be an unbalanced presentation, which the court was mindful of. Again, looking at hearsay evidence, I appreciate this is from mental health review jurisdiction in terms of it's a judicial review, but we had Mr. Justice Mumby, as he was then, saying that relying on hearsay evidence has dangers. And those are militated against if there are contemporaneous notes. He says that the tribunal must be alert to a well-known problem that constant repetition in official reports or statements may, in the official mind, turn into established fact, something which rigorous forensic investigation shows is, in truth, nothing more than institutional folklore with no secure foundation in either recorded or provable fact. So there's a note of caution there about listening to something and it's being repeated several times, perhaps by different people, and not going beyond that to really see what is bolstering that narrative. And again, of course, to taking it to the required standard of proof. So evaluating the evidence, as Bethan has mentioned, and in fact this was her case, the London Borough of Islington and AA, in front of Honourable Judge Hilda, but restating how evidence is evaluated. It can't be evaluated and assessed in separate compartments. A judge in all of these cases, to be honest, to me, appears to be having quite a difficult time reconciling these different pieces of evidence and correlating it with evidence that's even from the same person, which is contradictory, but goes to different findings. And some of the cases finding certain aspects proven, as in this case, the AA case, and others not proven, even though some of the evidence is coming from the same person. Initially, the neglect the evidence of neglect in that case came from the care coordinator, and Honourable Judge Hilda heard evidence from many parties in this case, and was able to weigh these aspects up, looking at hearing, obviously, what was said, but also hearing the degree to which things were happening at that moment in time, And the reason I say that is that if a finding is put in the Scott schedule as over perhaps a number of months or even years, what really needs to be clear is how specific the evidence is that is attached to that finding. So Her Honour Judge Hilda said she was not satisfied that the first allegation in this case was made out, accepting at the initial stage, the care coordinator's account demonstrated this evidence of neglect right at the beginning, but the brother was saying, well, we've had no social work input at this point. So the judge ended up saying, well, there was a crisis situation, but that severe neglect isn't something I'm going to find that just continued, because the situation changed. And indeed, the care coordinator said that was then an improvement when the care package was introduced. However, then the judge found that the following year, AA's care needs were not being adequately met in the home. And although that evidence was based on unsworn and untested testimony, she found that those significant concerns that were raised by the carers were ones that she was going to take account of, and find that despite that initial improvement, it wasn't sustained. After AA was discharged from a period of detention under the Mental Health Act, the judge was very clear that there was no evidence at all to substantiate the allegation of the continuous severe neglect, which was the alleged, the allegation that she was asked to make a finding on. The care notes provided a different picture, and the judge placed greater weight on that detailed contemporaneous record than a sort of almost global or general picture. And that again points to the need for a sort of more forensic analysis of what needs to be assessed. Another case, this was Stephen Simblett, Queen's Counsel, a member of our COP team here, and he was for AB in this case. And in this situation, again, Mr. Justice Baker having to carry out that evaluative process and finding, just conscious of time, so I'll just go to the last bullet point, because he'd found, as it were, against HT, M's aunt, on earlier allegations about the alleged forced marriage, but then was persuaded on the balance and satisfied on the balance of probabilities that HT's account was true in respect of a later event when M had begged her aunt to take her back to London. And in that situation, he said he thought carefully about the absence of any corroboration, because HT had gone and found M locked in the house was dirty, M was distressed, and in a poor physical condition. So no corroboration there, no contemporaneous notes, but the credibility of the witness in that case was sufficient for Mr. Justice Baker to be satisfied on the balance of probabilities. More evaluation, and I'm just reminded that the case of Enfield just at the bottom here, I'll come on to the AB interview in a moment, but in that case, the judge, although the local authority ended up not relying on the AB interview, the judge found it helpful to see SA's personality and presentation wasn't material to his findings, but it provided important information to the court and enabled direct observation of SA's general demeanour. All of that, I included it because, of course, Mr. Justice Mostyn has said it's not just demeanour that one is persuaded by, and was keen to emphasise the need for contemporaneous documents which support the findings of any fact that a party seeks to be made. Looking at P and how P is included in this fact finding, Mr. Justice McFarlane said in the Enfield case, it would seem counterintuitive if, as a matter of law, the Court of Protection was incapable of receiving as potential factual evidence reports of what a person who may qualify for and need protection may have from time to time complained about. So in that case, he decided that there was a wide discretion. It was under the old rules, a wide discretion, so he could take into account what SA had said. That rule has now obviously been updated in new rules, and it's contained here, paragraph 14.2e. So the court can admit, accept, and act upon information, oral or written, that comes from P or any protected party. And so that's where the discretion is. It doesn't mean that P gives evidence on oath or anything like that, or is cross-examined, but it allows information to be received from P into the proceedings. Conversely, in this case, it was quite an unusual case in front of a circuit judge where P had made allegations against his parents, and the local authority and the parents opposed P attending or providing information, and lots of submissions were made, and the court on that occasion didn't find that there was anything untoward or malevolent about the parents seeking to restrict P's presence or opportunity to give information, to try and restrict anything that he may say given his allegations. But he did emphasise that some of these decisions are for the litigation friend to make, and the litigation friend is not to be micromanaged by the court. So if the litigation friend says P would like to give this information, then the court will respect that. The real question about all of that unsworn, untested evidence is what weight is then attached to that evidence in any particular factual matrix. So the last topic is disclosure. I'll just skip through this. So firstly, there was a difference in disclosure as between the family courts and the Court of Protection. And again, back to the Enfield case where this was raised for the first time, Mr. Justice McFarlane saying that the difference may well arise because the rules for the Court of Protection are on ordinary civil litigation basis, and the family court was that there was a duty to give the court all relevant material. And I think we're 10 years down the line, that has shifted. The rule now imposes, under the current Court of Protection rules, imposes a duty on the parties to help the court further the overriding objective, and that includes being full and frank in the disclosure of information and evidence for the court. So it's very clear. I don't think if Enfield was happening now, there'd be the same hurdles or difficulties. In the, if, as we've heard, in the SA case where she had a short period of time detained under the Mental Health Act, there may be an issue about trying to get records from that period of detention. Just to note, if you do want information, statutory reports or something from a time in a psychiatric hospital, the tribunal rules provide that unless the tribunal gives a direction to the contrary, information about mental health cases and the names of any persons concerned in such cases must not be made public. That means you have to apply to the tribunal in order for them to agree for a specific purpose to release those documents or disclose those documents. So the ABE DVD, excuse me, this issue arose because it seems it kind of blew up at court, as it were, where it was revealed that unbeknownst to the court and indeed to the litigation friend, the police had conducted an ABE interview of SA, and the court was not pleased about that, and essentially made it very clear that where there are live proceedings, particularly where you have capacity assessments which says that P does not have capacity to conduct the proceedings, and there may be at least initial evidence to suggest that P can't make decisions about where they live or the care they are to receive, then in those circumstances, at least P's litigation friend must be put on notice if there's going to be any interview. And in that case, the judge couldn't help but remark that with all that capacity evidence, the AB interview took place without anybody saying, has P got capacity to consent to being interviewed? So again, to emphasise Bethan's point, when we start looking at these facts, start at the very beginning and be rigorous at the very beginning as to what needs to be in place to ensure that you can in fact use the evidence that is being explored. And then I think I'm up to time, so I'll just quickly do this, that disclosure for categories of documents, there's third-party disclosure, of course, there's as well as disclosure from parties who are parties to the proceedings. Often that disclosure goes to P's litigation friend and there's onward disclosure, but third-party disclosure can be from all kinds of different people. You need an order from the court. It needs to be specific. In this case, there was a discussion about the police seeking disclosure of the psychologist reports of P, and that's something that was going the other way, as it were, that you've got the third party who's trying to get hold of reports of P, potentially to look at evidence that may or may not impact on P, but may impact on potentially a prosecution. So it's very important to look at the purpose of the disclosure. If the disclosure is ordered, question as to the extent of it in terms of time period, whether or not it needs to be redacted, anything like that. And finally, a couple of scenarios just to mull over. One case, X is a party, driven as he or she was for P's welfare, threatens to go to the press about the perceived injustice of P's situation. X was in receipt of highly confidential material. So there are some really tricky disclosure issues to think through there. Previous convictions for offences of sexual touching on a child under 13, they were disclosed in respect of the subject of P's affections in a sexual capacity case. And obviously other considerations apply there. And then finally this, I've started with a ship at the beginning, I've got a plane at the end. I'm obviously needing to get out of lockdown, but in this case, if there is email contact that P is emailing, and obviously P often does, emailing litigation friend or solicitor, what happens to that if inadvertently P forwards an email and the social worker or another person, a care worker, is involved in that email? What happens about the disclosure of that email? And some very clear advice and guidance was given in this recent authority last year, which basically means that if it's litigation, then it's for the purpose of litigation, then P, particularly as a vulnerable person, their privacy and their privilege of that communication will be protected and it will be stopped from being disclosed into proceedings. I'm going to stop there. I'm sorry that I whistled through, and I'm just going to stop sharing and hand over to Mai-Ling. Thanks, Mai-Ling.
Hello, I'm just going to find let me see if I can do this now. There we go. Well, just carrying on from what Helen was saying about disclosure and the sorts of matters that can be disclosed into fact-finding hearings. I'm a family practitioner as well as practicing in the Court of Protection, and there are, I think, probably many more fact-finding hearings in family proceedings than there are in the Court of Protection. And one of the issues that, in terms of disclosure, that currently constantly coming up against is disclosure of social media and Facebook accounts and WhatsApp accounts as part of that process in terms of determining the factual matrix and the central sort of question of who done it in these fact-finding hearings. So just looking at the issue of vulnerable persons in the participation of fact-finding hearings and court proceedings. When Helen was going through the issues in terms of preparation for fact findings, it's one of the key issues that should be addressed at the beginning of any consideration in terms of a vulnerable person giving evidence as to what special measures can be put in place. Now, the Court of Protection rules don't contain any specific rules in terms of vulnerable witnesses or vulnerable parties. And so looking across to the family proceeding rules and now to the civil procedure rules with the amendment to the overriding objective and practice direction 1A, we can see that across jurisdictions, there are provisions both in criminal, family, immigration, and now civil proceedings in terms of vulnerable witnesses. And so in terms of looking at 14.2, although there are no specific rules, the court does have the power to allow or limit cross-examination, and also to control evidence and the nature of the evidence on which the court's going to have to determine. And so for those reasons, although there are no specific rules, the issue of vulnerable witnesses is one that we should all have at the forefront of our mind, particularly in preparation for fact-finding hearings. And that's the amendment which is coming in on the 6th of April. And so what can we learn from vulnerable witnesses in the family and criminal jurisdictions? Well, first of all, the rules in respect of vulnerable witnesses in terms of family jurisdiction and criminal jurisdiction are not the same. They're different. And of course, that's really because that there are fundamental differences between family and criminal proceedings. In family proceedings, the focus is on the welfare of the child. In criminal proceedings, it's determining whether or not a party is guilty or innocent. There's a difference in terms of the burden and standard of proof, and also whether or not the vulnerable adult is a party. Also issues in terms of public or private hearings, because of course in criminal proceedings there are a lot more people present in the courtroom, including the jury. And also the use of AB interviews and pre-recorded evidence is very different in the criminal jurisdiction than in the family jurisdiction. And fundamentally because in criminal proceedings, of course, any defendant in terms of their evidence in chief, which is essentially in family and civil proceedings, there isn't that reliance on written evidence and written statements of evidence, because it's so important for the jury to hear what the parties have to say and the witnesses have to say. So although it feels like there was a sort of huge cultural shift, really, although of course in family proceedings, I think that I wouldn't have thought that I was particularly insulated to the needs of vulnerable witnesses when the rules came in 2017. But in fact, I found myself really facing a huge sort of cultural shift and some resistance, because although, as I say, I wouldn't have thought myself particularly resistant to change. I think we all can change. We all change to watching videos all the time. But I did find that some of the rules and guidance that we had to then follow in terms of the amendment to the family procedure rules butted up against quite a lot of resistance, because there was always a feeling, well, we must have been doing this right all the time. Why are we now being told that we've been doing things differently? And I think it has resulted in, as I say, this quite significant shift. And even though, I think that dealing with children and also parents with learning disabilities or cognitive deficits, a lot of the time, I think the family court felt that it was quite able in dealing with them. But once these rules came in, it found that we really weren't. In terms of family proceedings, the focus had previously been on the issues to do with children giving evidence and what protection children needed. The criminal courts were way ahead of the family jurisdiction in terms of that, and the sort of overall squeamishness, really, if I can put it like that, about children giving evidence in family proceedings was really addressed in the case of Reed W, which is some 11 years ago now. And that resulted in the situation being formulated in that there's no presumption that children should give evidence, and there's no presumption against children giving evidence. But yet we still find in family proceedings that children don't often give evidence in the same volume as children give evidence in criminal proceedings. And I won't focus too much on that because it's unlikely that a child would give evidence in the court of protection. But in looking at what special measures are put in place in the family courts, the sort of minimum might be, if you've got a vulnerable witness, a screen, or reorganising the court slightly so that a witness doesn't have to see their alleged abuser when they're giving evidence. The court always requires some warning about that you have to request that these special measures in terms of screens are put in place before the hearing. There can be a sort of even when you've asked in advance for special measures to be put in place by way of a screen, there's a general sort of like shifting of furniture and screens coming, rather like sort of like hospital trolleys being sort of wheeled in to section the court off. But it does really help when people are very, very nervous about confronting someone that they perhaps haven't seen for some time. The other issue is to ask for separate waiting rooms. That can make a huge difference. But about people feeling safe coming into court and knowing that they're not going to accidentally bump into somebody, using different exits, and also ushers really sort of managing the sort of flow of who's coming in and who's waiting, and making sure that in fact if someone's sitting behind a screen that they go in first ahead of the person they don't want to see. The arrangements are similar in criminal proceedings, but I think there's more use of video link evidence where a child will be in a room away from the court and will give their evidence via video link. I have had in family proceedings, much like sort of ABE interviews that Helen was talking about, that where a vulnerable young person has had pre-recorded, given pre-recorded evidence because of the impact of actually coming into the courtroom and giving evidence in the courtroom. And that was done in a sort of ABE style way with a social worker and an intermediary in a hotel. And I think we had one as well at the social services offices. One of the key differences between the family and the criminal jurisdiction has been this issue about the statutory prevention of cross-examination by a perpetrator of abuse or an alleged perpetrator. That's been an outstanding sort of howling gap really in the protection of vulnerable witnesses in the family courts, and that's soon to be addressed by, it's now clauses 65 and 66 of the Domestic Abuse Bill. So in terms of moving on now to think about how you identify vulnerability in terms of a witness or a party. In family proceedings, of course, if it's a parent, there will be assessments of the parents, most likely a cognitive assessment or psychological assessment, which may well flag up at that point the impact of proceedings. Because rather surprisingly, proceedings can go on for quite some time. And I've had parents as well who've had previous sets of proceedings where there weren't measures put in place when there've been multiple sets of proceedings. But with as I say, this cultural shift, they having previously not had the assistance of an intermediary or special measures, then were enabled to give evidence with the use of an intermediary. The sort of list, and I'll just skip through it, are the sort of things that you might well imagine, nothing that's going to take you by surprise. However, I do find that sometimes I've been working with a client for some time, and again, as I say, I wouldn't say that I thought that I was particularly lacking sensitivity, but have been surprised by the content of intermediaries reports that have highlighted a much more significant deficit than I was aware of. I mean, I might know something's wrong. I take longer to explain things. I make sure I go over things. But the intermediaries reports, which we'll get onto in a moment, really highlight very particular difficulties and the way in which somebody understands things according to how they process information. So I won't take you through these. This is practice direction 1A, which I'll set out again. I won't take you through that. But the sort of measures are the measures that we've just talked about. At one end, the use of the screen, and the other end, pre-recorded video evidence. One of the very common features that we have in family cases now is the use of an intermediary. And what is, if you haven't had an intermediary's report or the benefit of working with intermediary, they really can be so helpful. It's not just about someone sitting next to somebody and reassuring them. It goes much further than that. I've had cases with intermediaries where they've produced sort of pictorial chronologies for witnesses that found it very stressful, would get lost in their answers to questions because they were poor on dates. It's all those sorts of things. The use of dolls for describing, for being able to physically describe what happened, and those types of things are really very useful. But it's not all parties that have a learning disability that will require an intermediary, and that's something to, or special measures, that's something to bear in mind as well. Quickly dealing with funding. In the family courts, the HMTCS fund intermediaries, and they will fund the report and they will fund the intermediary attending court, but they won't fund conferences. But often, if you have a judge who will list the hearing early with the intermediary attending early, that can assist greatly. Found this interesting case from last year about advocates, and there Mr. Justice Kean directed payment for a lay advocate, which was quite an interesting case. And there I just set out what I've been through in terms of intermediaries. I'm aware that I'm running out of time. And there I set out there the guidance. And that's, of course, who's going to pay for it is a really central feature. In terms of, so the HMCTS and sometimes local authorities will pay for advocates or intermediaries. A ground rules hearing, they deal with the recommendations from the advocates, and the sort of recommendations you'll have from the advocate, the intermediary, are regular breaks, the type and style of questioning. And I give an example of the type of questioning that produces an entirely sort of different answer. And that's one of the things that I say in terms of a cultural shift. One of the ground rules can be that the counsel has to provide questions to the intermediary to look over them before a witness is cross-examined. And that is something that nobody really likes doing. And there's a lot of resistance in terms of, well, is that going to take the force out of cross-examination? And really, the really troubling thing, as I say, when I first saw an intermediary's report and I first saw the type of a mother with a learning disability gave like essentially the same question, gave 5 different answers depending on how the question was put, I found it very troubling indeed. There's a list of resources, and the Advocates Gateway is a really key resource, and the toolkits provided in that. If you've got any questions, you can ask me afterwards.
Thanks very much, May. Lovely. I'm going to hand straight over to you, Rachel. Thanks.
Thank you, Helen. So can you see my slide there? Great. So I'll be speaking about remote and hybrid hearings, which of course has been our reality for the past year. And it is amazing that today is actually the 1-year anniversary of us going into our first national lockdown. And I can certainly remember watching Boris a year ago today and just, feeling like the entire world had changed. So it was on the same day that the Lord Chief Justice issued directions to the judiciary in respect of hearings in the county and family court. And the guidance stated that remote hearings would be the default for the foreseeable future unless there was genuine urgency and no remote hearing was possible. And then about a week later, Mr. Justice Hayden published remote access to the Court of Protection guidance, which stated that the same approach was to be taken in the Court of Protection. And this guidance, interestingly, invited imaginative ideas to ensure that P participates in the proceedings where they're able to do so safely and proportionately. And at the time that guidance was published, the concern seemed to be that actually it might be harder for P to participate in the proceedings when they were happening remotely. But as I'll come on to later, that perhaps the reverse has been the case. One thing that's certainly true is I don't think anyone would have realised when this document was published that the situation would have persisted for a year. And I've got a statistic at the bottom of that slide, which I found a bit scary, that we've actually been in a full national lockdown for 53% of the last year. So obviously more lockdown than not being in lockdown, but there we are. So, of course, the issue of remote hearings and when it is appropriate to have a remote hearing has now been looked at by the Court of Appeal. And in relation to fact-finding hearings, there have been some judgments of in the family court, not specifically in relation to the Court of Protection, but of course the same principles apply. And this is the case of Re P, which was a family law case concerning allegations brought by the local authority against the mother for falsely fabricating illness in her 7-year-old child. And what happened in this case was that the mother was unwell and she had some issues with her internet connection. So the case went before the president of the family division, and he ruled that the case should be adjourned and it couldn't proceed remotely. And of note, he stated that just because a hearing can be conducted remotely doesn't in any way mean that the hearing must be conducted in that way. And I've headed this slide the Jurassic Park principle because wasn't my original idea, because this is when I was reading about this case, other people had called it that, but I didn't know why they were calling it the Jurassic Park case. And then I discovered that in Jurassic Park, apparently at some point somebody says that just because you can clone dinosaurs doesn't mean that you should. So if that helps you remember it, then all the better. So in the slightly later case of Re A, the Court of Appeal set out 10 factors to consider when deciding whether or not there should be a remote hearing. So I'm just going to go through them. So the first one is the importance and nature of the issue to be determined and whether the outcome is sought as an interim or final order. And it's certainly been my experience that interim hearings are very routinely listed remotely at the moment. And if it's a final hearing, then there might be more consideration given to the necessity for it to be an in-person hearing. The second point is whether there's a special need for urgency or whether the decision could await a later hearing. That's sort of an interesting one because I think at the time perhaps this case came out, there was the idea that the lockdown might be lifted soon and that we'd all be back to normal. But I think what we've all realised after a year of this is that back to normal keeps being around the corner and keeps not happening. So it may be that, for example, in the case that one of the cases I was looking at, the mother was self-isolating. And so in that kind of situation, it might be that you could have the hearing later and obviously then parties won't be able to attend. But I think we've maybe got away from this idea that we'll all be having normal hearings in the near future and that it can be adjourned to await a time when things are, as it were, back to normal. The third point is whether the parties are legally represented. And of course, when a party is appearing in person, then there are going to be concerns about their ability to engage properly with a hearing remotely, particularly if that is a fact-finding hearing. The fourth point is the ability of parties to engage with and follow remote proceedings meaningfully. And this, of course, overlaps with what May was talking about vulnerable witnesses. And there will be cases where, for various reasons, people will find it very difficult to engage with the court proceeding remotely, both because of vulnerability and also perhaps because of financial or other matters, such as lack of access to the necessary technology. And number 5 is whether evidence is to be heard or whether the case will proceed on the basis of submissions only. And of course, if it is going to be a case just based on submissions, then that might be rather easier to hear remotely than if evidence is going to be heard. And number 6 is in relation to the kind of evidence to be looked at by the court. So whether or not it's going to be given by a professional or a lay witness, and whether it's written or oral, And again, professional witnesses might find it easier to give evidence remotely than lay witnesses. So number 7 is the scope and scale of the proposed hearing, how long it's expected to last. And again, if it's going to be a very long hearing, then it might be thought that it makes more sense to have an in-person hearing and to make necessary arrangements for that to be a COVID-safe hearing. And number 8, the available technology and whether it's going to be telephone or video. Although I have participated in some hearings over the past year where cross-examination has had to take place over the telephone, that's clearly not ideal at all. And the court did note here that a telephone hearing is likely to be a less effective medium than using video. And then number 9 is the experience and confidence of the court and those appearing before the court in the conduct of remote hearings. And at this point, I think most lawyers are very au fait with it, but of course, again, lay parties might be a different story. And then finally, number 10, any safe alternatives that might be available for some or all of the participants to take part in the court hearing by physical attendance. And it is the case the courts have been making huge efforts to make things COVID safe and put physical distancing measures in place, cleaning regimes and things like that. So in the case of a local authority via mother and others, this was actually a case where the mother had been required to self-isolate, and that was why she wasn't able to attend the in-person hearing at the point that it had been listed. And the judge applied the principles that we just looked at, and his conclusion in this case was that this case fell into a category where there wasn't a lot of contemporaneous evidence for the court to go on, and therefore the evidence that would be given by the witnesses was particularly important. And so the decision of the judge in this case was that if in-person attendance could be facilitated within a reasonable time period, so after the mother's period of self-isolation, then this would be preferable. This case is quite interesting because the judge goes through the case law about demeanour and witnesses' demeanour. And of course, there is a line of case law which stresses that demeanour is only one thing to take into account and not much weight should be placed on it. So what he was saying was that in many cases it's not going to be so important to have the witnesses come in, particularly given that demeanour is not something that you should rely on to any great extent. But in this case, there wasn't a lot of other evidence, so he thought it was important. So in preparing for this seminar, one of the things that we did was we asked other members of the team about their experiences appearing in remote or hybrid fact-finding hearings, and any kind of thoughts or comments that they had. And there are quite a few practical tips, if you like, that I wanted to share with you. And I think something that is really important is making sure that witnesses have a paper bundle as they would do in court, because certainly my experience has been that there's a lot of time that's wasted in court these days when witnesses or even lawyers or the judge are sort of struggling to find references in electronic bundles, and having a paper bundle does just make all of that so much easier, particularly if people are on using one screen anyway to appear in the hearing, and it can be quite difficult then to be manipulating a bundle on that same screen. There's also the point that witnesses need access to a holy book if they want to swear on that, and otherwise they'll need to affirm. And in terms of communicating with clients, I think WhatsApp is often something that I've used, because one of the things that's good about WhatsApp is that you can actually kind of use it from the computer, which means you can be using it while looking at the screen and looking at what's going on in court. But of course, it's so important to be in touch with your client before and after the hearing, and of course during the hearing as well, if you do need to take further instructions. And I make sure I always stress to clients that if they do need to talk to me, then we can just take a few minutes out of the hearing, and that is possible. And then in relation to interpreters, one of the things that I've recently noticed is that it can be much easier if the interpreter calls the party directly with both people on mute and simultaneously translate, rather than doing that kind of in the hearing and meaning that everything takes much longer, because of course in an in-person hearing, the interpreter would be sitting close to the relevant person and, as it were, whispering in their ear. But it's very different when you're in a remote hearing. So one kind of accidental benefit of the transition to remote hearings has been that it's actually become much easier for observers to attend. And that has increased public understanding of the work of the Court of Protection. And I do have to pay tribute to Celia Kitzinger and Jill Looms-Quinn in relation to this, because they have established something called the Open Justice Court of Protection Project, where they're encouraging people to attend hearings in the Court of Protection and raising awareness of the right to attend these hearings. And quite recently, Celia Kitzinger wrote a blog post reflecting on, as it were, a year of remote hearings and a time when she had personally attended many hearings as an observer, with perspectives from different people who had also been involved in these remote hearings. And she felt that there were some significant changes happening as a result of observers being able to attend so easily. So something she pointed out is that barristers are increasingly opening cases with introductory summaries, clarifying and highlighting key legal concepts for observers, and that the fact that lawyers observed might mean that they're on their best behaviour, as it were. So the presence of observers can actually mean that the case kind of proceeds in a more smooth and a better way than it would have done otherwise. There are also other benefits to remote hearings that have emerged over the past year, and specifically in the Court of Protection context. A lot of people have said it's made it easier for P to attend and to actually feel included, which is great, of course. And in addition, it can be a lot more cost and time effective to have experts appearing remotely, and also means if these are people who are busy NHS consultants, for example, people working care homes, that it relieves pressure on these services which are very stretched in any event. I think many lawyers have felt that remote hearings have been good insofar as less time is spent commuting or waiting to be called on at court. And then lay parties as well may feel more comfortable giving evidence from their own home, and they also don't have the stress of travelling to court and everything that goes with that. However, there are of course also drawbacks to remote hearings, and I think most people have had the experience of being in a remote hearing and finding that internet connectivity is a problem, and this can be very disruptive. And of course, if it's a fact-finding hearing, then it can be particularly off-putting and stressful for whoever is giving evidence, particularly if it happens during somebody's evidence. In addition, the concern is that hearing a case remotely can have an implication for a judge's ability to get a feel for a case and to see how parties interact in the courtroom. And there's also been concerns expressed that remote hearings can mean that there's less gravitas attached to court proceedings, because people are just in their homes. And there've been incidents with cats appearing on screen. I actually was in a remote hearing earlier today where a cat appeared on screen. And although that might be sort of fun, it's perhaps not so fun when you think about the very serious nature of some of the questions that the court is being asked to determine, particularly in the Court of Protection. And then going back to May's presentation about vulnerable parties, it does seem that when someone is especially vulnerable, then that really can affect their ability to engage in a remote hearing. And that would be one of the situations where a hybrid or in-person hearing would probably be preferable. So looking ahead to the future, last week the Lord Chief Justice issued a message about courts recovery, which essentially signalled a hope that normal service would be resumed over the next few weeks and months, as the number of people who've been vaccinated increases and restrictions ease. But he did say that remote and hybrid hearings will still play their part in managing footfall. And of course, it does seem that social distancing in some form will be with us for a while yet. But the question that I think is unanswered really is to what extent remote hearings might continue to play a part once we're out of this current pandemic, and to what extent they might still be preferable in some cases. So I think at the moment it's hard to say because we're still in the middle of the pandemic, but certainly I think there will have to be a conversation about to what extent they're here to stay, and I hope that this has sort of helped to kind of outline some of the key issues that will need to be looked at as part of that conversation. So yes, thank you very much. And I think now it's time for questions. So I'll hand back over to Helen.
Thanks very much, Rachel. Certainly some of what you were saying there was resonating, and I'm sure with others, with our daily lives at the moment. I think we've got 3 minutes left before we switch off at 6:30. Thank you to all those who've patiently stood the course, haven't sloped off for refreshments. Sorry, we can't offer you any. So I haven't got any questions that I have seen, so I'm just going to go straight to Bethan and ask for your top tip, please, before we close, if there's no questions.
Okay, my top tip as a final point, I guess it's a tip to myself, really, as much as it is to anyone else,
Okay.
for what it's worth. I think in a fact finding, it's always worth getting the disclosure, get the disclosure and just spend a lot of time looking at it. It may not say what everyone thought it said, and it will be the thing that the judge is interested in. And that needs to be done really early on in the case, really, especially if you're the applicant bringing the case. That's it.
Lovely. Thank you very much. I don't know if either you, May, or you, Rachel, have anything that you want to add. May, you've unmuted yourself.
Well, I was going to say I really endorse what Bethan said, that you have to, when you receive all those pages and pages of social services disclosure, it is a really, I sort of feel like I've got to tie myself to my chair as I read through files and files of it. But within it, there is often really important, very crucial evidence. So it is that painstaking task of just reading everything in preparation for fact finding.
Absolutely. Thank you very much. And it really emphasises looking at those records. You start to see, or I do at least, the benefit of good record keeping stands out a mile, because the bits where there are gaps, where you don't want there to be gaps, all of a sudden assume a significance that you might not have otherwise realised. We are literally at 6:30 by my calculation, and we are got plenty of people who are obviously looking to go and have something to eat and something to drink, quite right too. So thank you all for joining us this afternoon. We're all looking forward to being back in chambers where we can do what we enjoy doing what we enjoy doing as well as, and meeting people in all social situations. So stay well. Thank you for joining us, and all the best.
Thank you.